I mean, honestly, this was expected. Donna Adelson wants a new trial. She pointed her fingers at the jurors that have spoken out publicly about this. She's also pointing her finger at Judge Everett, the way that he ruled in the courtroom, how he conducted himself between him and the state, because, they're saying that like, oh, well, the judge seems to really prefer the state over the defense, and that's pure bias right there. And not only that, there's also the conduct of the people that were attending these trials on a day-to-day basis. The defense was saying they're laughing at us. That's a distraction to the jury, and also it could just show the jury that maybe we're not to be taken seriously. Okay, I definitely have something to say about that, but we'll get to that later on in the video. Now, let's start with the jurors that have spoken out so far. We have juror number 7, who was the foreperson. She came out on TikTok and talked about her experience as a juror foreperson, her thoughts about Donna, her thoughts about Wendy. And then we also have juror number 6, who did like a little mini interview with a news station. And then he also went on a podcast with Surviving the Survivor. I think that's what it's called. Hope I got it right. And he talked with them for about an hour, basically sharing his experience. And the interesting thing about him, he was like, I went to school and I'm majoring in a different, major. Now I kind of want to change to pre-law because all this has been very interesting, this experience that I've had as a juror. In Donna's motion, she talks about what jurors are not permitted to do while they are doing their jury service. And what's really highlighted and in bold is posting information on social media. So here's what they wrote. Subsequent to the trial, juror number 7 went viral on TikTok concerning her jury service. She revealed that she posted to TikTok during the trial. In reviewing juror number 7's TikTok account, the undersigned identified she posted on TikTok that she was selected as a juror on August 26, 2025. A flash of this video will be provided to the court, as the undersigned has been informed that particular TikTok was deleted by the juror from her account. Number 7. The undersigned seeks to interview juror number 7 concerning her social media activity during the trial. Now, she's already said in her TikTok video that she was posting while the trial was happening. She was on social media. She wasn't told to not be on social media. She was told to not seek out information about this case. And she said that she abided by that.
Concerns as to me being on social media and posting my TikToks in the last week or two. There was no rule stating that we cannot be on social media. The rule is provided by Judge Everett in this case, okay? We cannot seek out information about this case. We cannot talk about the case with anyone. We cannot listen to others talk about the case. We cannot do anything in regard to during the trial. But now that I'm released as a juror, I have the freedom to say and do whatever. But also in that regard, I don't watch the news. It's depressing.
Now, she also talks about the algorithm, right? Because for us, we're watching true crime. We're like, how could people not know about the Donna Adelson case? This is like everywhere. Everyone must know about this. Well, that's not necessarily true because it depends on your algorithm. Someone who is not interested in true crime, they're not going to get true crime stuff showing up in their feed, right? Maybe like the viral ones. For her, she was saying that she usually gets mommy content. That's what she gets recommended to her feed.
My For You page on my TikTok, where I am the most active, is mostly like TikTok shop videos, like members of like the moms of TikTok community, because that is the content that I typically engage in.
They might want to question her, but will she really say anything differently than she's already said on TikTok? Maybe they're like, hey, she's lying on TikTok. She did find information about Donna Adelson, and that we have her here sworn under oath, then maybe she will tell the truth. So maybe that's what the defense is thinking. But like I said, like nothing really alarming really popped in my mind when she was talking about this on TikTok, at least not obviously to me. You guys, if you guys thought of anything, let me know. Now, focusing on juror number 5, I think it's a typo here because before this came out, they were reporting this juror as juror number 6. So I don't know if it's a typo or maybe the news were wrong the entire time. Court TV, juror number 6, WTXL, ABC 27, juror number 6 right here. That was 7 days ago. Lord, juror number 6. Juror number 6, juror number 6. And listen, I know typos, I know mistakes happen, but I feel like this is just kind of a representative of what was going on during trial with a lot of the mishaps on the defense's team. This is what they wrote. Juror number 5 appeared on the podcast Surviving the Survivor. Oh, see, I had the name right. During his appearance, he revealed he considered how Mrs. Adelson reacted to the evidence and testimony admitted during the trial. Okay. Although he subsequently stated he obviously did not consider that during deliberations, that he considered Mrs. Adelson's reactions whatsoever is concerning, as her reactions are not evident and are extrinsic or external, rather than which inheres in the verdict. Okay, that was a little bit hard for me to read. As a result, the undersigned seeks to interview juror number 7 concerning his consideration of Mrs. Adelson's reaction to the evidence. I don't know who wrote this because I don't know if that's also a typo right there. I think it is. It's supposed to say juror number 5 or juror number 6. Who wrote this? When I was listening to the podcast, it seemed obvious to me that he did not consider Donna Adelson's reactions whatsoever. As a matter of fact, he even went on to explain further by saying that, yeah, I kind of just pretended like she wasn't in the room.
Yeah, I did my absolute best to pay zero attention to Donna as if she wasn't in the room. But which I think I did never speak to anyone about this in deliberation, but I feel like that's probably what everyone on the jury was doing, because that's not something that we can hold against her in the deliberation. It's not evidence. Her reaction to something in the courtroom could be due to numerous factors that are outside of like what happened in the timeline of this case. So I did my best to not pay attention to her being behind or being with her counsel.
And that's fascinating that you're kind of treating her as sort of the invisible woman, because we're all, what is she wearing today? Did you see her roll her eyes? Would you pick up on eye rolls and things of that nature?
I hardly looked at her.
Really?
I don't know if this defense team just has a penchant for just trying to distort reality. Unless there's a different segment that I haven't seen where he talks about Donna's reaction, but that right there just says that, yeah, I barely looked at her. I wasn't paying attention of her. I wasn't paying attention. I was paying attention to her. Oh gosh. All right, guys. Well, let's move on to the next one. So they get into all the juror misconduct stuff. If a juror misconduct is confirmed from the juror interviews, the undersigned will request leave to make more extensive arguments regarding why the juror misconduct in this case warrants a new trial. I think it seems a little weak here, but there's some other stuff in here that I think Donna might have a stronger case for. Let's keep going down. The defense is going to go through, sounded weird. The defense is going to go through the charges that Donna Adelson was found guilty of. Those are, again, the 3 charges. For count 1 was first-degree murder, and they start with not Drina, but it was with Patricia Bird, who testified. Again, Patricia was the inmate that was with Donna, and she said that Donna confessed to me. She said that she didn't mean for it to go far. She just wanted her grandkids back, something like that. I'm sorry, probably quoting it wrong, but that's like the sentiment of it. Anyway, so the defense is going to talk about how, Patricia Bird, she's not credible. And, I agree. I can agree why the jury might think that Patricia Bird is not credible, because Patricia Bird said that, she told the 2 investigators that came to interview her that Donna offered her like some financial incentives, and Donna also confessed to her. However, when those 2 PIs came and testified for the defense, they were like, oh, she didn't say that. So let's say we take Patricia Bird's testimony and the jury discards it. Well, the stronger testimony, in my opinion, was Drina. And the reason why was because her testimony was accompanied by the notebook that Donna herself admitted that she wrote in it when she was trying to make a script for Drina and to have her rehearse it to, the investigators and the state attorney's office. Now, remember the surveillance footage that the defense decided to show the jury where it had Donna at her jail and she was with Drina, they were writing together. A lot of us were kind of confused, like, oh, why? What is the defense's angle here? What were they showing? Well, now it makes sense. The defense was trying to show the jury that, well, actually, it wasn't just Donna writing the entire time. It was Drina and Donna. It's like, I don't know if that really made it any better. Donna was still writing in it, and Donna's the one that knew of Charlie's defense and his conspiracy theory, unless you would believe that someone like Drina, who, by the way, was convicted because she was an ongoing drug addict and she would keep breaking probation, would she really know what Charlie's exact defense would have been? Would she have known what Katie's role was in it was? Or does it make more sense that Donna was the one who knew the exact story of Charlie's defense and tried to coach Drina into giving false testimony? This is what the defense wrote. The same is true of Drina Bernhardt. Ms. Bernhardt's motivation to lie was and is significant. With 27 felony convictions and facing a mandatory 15-year prison sentence as a prison release reoffender, Bernhardt's credibility was significantly impeached. The only one who testified this was Mrs. Adelson's words rather than Ms. Bernhardt was that Ms. Bernhardt. What was that sentence? Hold on. The only one who testified this was Mrs. Adelson's words rather than Ms. Bernhardt was Ms. Bernhardt. However, the surveillance video admitted into evidence establishes that she and Mrs. Adelson worked together to write the script. Like I said, Donna was still participating in it. The theory of the state's case was that the defendant is guilty as a principal to the charge of murder because she agreed to the plan that was carried out by her son, Catherine McBanois, Sigfredo Garcia, Luis Rivera, and that she paid for the crime to be carried out. She paid for the crime be carried out. She paid for the crime be carried out. Who wrote this? Okay. There's no evidence that Mrs. Adelson committed any act or uttered any words in furtherance of the offense prior for it to being completed. And for that reason, the evidence is not sufficient to support her conviction as a principal to first-degree murder. Additionally, there is no evidence other than the adoptive admission from Charlie Adelson's trial testimony that Mrs. Adelson was aware of her son's plans until September 17, 2014. I think it was until towards maybe the end of the trial that I figured out that the defense's angle was that, hey, this is the reason why Donna was writing those checks is because Charlie confessed to her that Charlie was being extorted. And Donna just wanted to help out. And that's why she started writing these checks. And it wasn't until when she started writing these checks was when she had knowledge about the hitman killing Dan Markel and Charlie being extorted and Katie being involved. So that was their retrospective story to explain everything that happened. However, I'm going to heavily disagree with this by saying that even though the defense is saying that there's no evidence to support that Donna knew of the plans until September 17th, there's a lot of circumstantial evidence that the jury could have used in order to infer that Donna indeed did know and that she did plan to have Dan Markel murdered, and she planned it with Charlie. But Charlie was the one that had the connections to Katie and Katie to the hitman. Now, why I think Donna probably knew before September of 2014? Well, for example, they're saying that Charlie was the one that said Donna knew in September 2014. Well, Charlie could have lied while he was testifying on the stand. It seems like he was lying about a lot of things during his testimony.
I'm telling you what happened to me, and I was told that if I didn't pay in 48 hours, I would be killed.
They don't appear to look like you just gave her $138,000 under duress, do they?
She told me, the last thing she said to me before she left the house is, can we just pretend like this never even happened?
You scared that if you broke up with her that she would sick the Latin Kings on you?
No, because I had every intention of paying every month. When I broke up with her and I said, listen, I don't want to surround myself with this. I'm scared. She said that she was going to come every month and pick up the money and protect me. And I realized that she's the one who's protecting me, and she's not involved with these people because the extortion never went up, and Katie was always broke.
She was involved with them because she had a child with the guy.
Did you cause the death of Professor Dan Markel?
Absolutely no.
Did you hire anyone to kill him?
No.
Did you put any letters in any diaper bags of Katie Magbanawa to have Professor Markel killed?
No.
Not only that, when we look at the circumstantial evidence, right, like the top ones for my head right now, I'm thinking about the birthday invites. So, for example, remember they tried saying that, oh, Donna was the one that sent these invites? Oh boy. So in those birthday invites, the boys' names had been changed to Adelson. Dan Markel was still alive at that time. The defense was trying to say that, well, maybe it was Wendy who was the one that sent those invites. And I think the state got confused, thinking that maybe the defense was going to point the finger at Harvey too, that maybe he sent the invites, and the defense was like so offended that the state had it misconstrued. Although I can see why the state took that route, because they were already trying to say that Harvey could have sent emails out, right? So they tried to blame Wendy, for example. However, Donna communicated with a friend saying that, like, oh, did you get my invites? Did you get my invites? And then Donna also, I think, had maybe like some troubleshoot issues or something like that. And so she was also emailing the invites company or something like that, oh, like, I input these invites in, like I input their names in. So it's like, okay, it's obviously Donna who sent those invites out.
To Evite, inquiring about whether the Evites had been sent. The title of the email, I believe, is Have My 14 Invitations Been Sent? She's following up. It is signed by Donna Adelson, following up on whether those Evites have actually gone out. And it indicates that basically she's unfamiliar with the process, but she had listed the attendees under the contact section on their form. Correct.
And does she also send a message to another person saying, did you get the Evite? Did you get my Evite?
Yes.
But like I said, that on its own, of course it doesn't stand. Of course it's not strong. Then we look at the dad's birthday present before Dan Markel was murdered. So Rob, who was the eldest son of the Adelson family, he testified saying, well, there's no birthday present pending for dad that year. And typically, if there was a birthday gift, Donna's usually the one who organizes it. And she does it by, reaching out to people. She collects like money so they can put the money together, buy a gift for Harvey. But there was none of that time. There was also Donna sending a text message to Charlie that just seems really weird, because she talks about how, hey, I might be alone. Make sure you delete this text message. And then she continues to talk about the birthday present.
Right before we broke in the afternoon, we saw we're back in March of 2014. Donna Adelson tells Charlie Adelson she has to talk to him about something private while she's on the road on the way to Gainesville, and says to erase this text. Do you remember that?
I do, yes.
Okay. And then a few minutes after she sends that message, she says the subject of the private call is going to be about Dad's birthday.
Correct.
Dad's birthday gift, actually. Is that right?
Yes.
And she does not tell him to erase that text where she's saying the subject of the private call.
That's correct.
Now,
However, Georgia brings this up. Why would Donna instruct Charlie to delete the text message on his phone? It's not like Harvey has, I don't know. Does Harvey have access to Charlie's text message all of a sudden? If anyone were to delete text messages because she didn't want Harvey to see, it would be Donna deleting it off her phone because maybe Harvey also uses it to make phone calls or something like that as well, right? Why delete it on Charlie's phone?
how is you erasing the text going to prevent your dad from seeing it on your mom's phone?
Well, if my dad looked at my mom's phone, they'd see the text and maybe know she's planning for his birthday.
You weren't with Dad, she was with Dad, just to clarify.
Yeah, she was with my dad.
And the text that she asked you to erase, that particular text didn't say anything about a birthday or paella. Can we agree on that?
No, but I knew what it was about.
And then I think in the planner, they were planning on possibly canceling Harvey's birthday. Why? Because the first hit attempt was in July. Harvey's birthday would have been a couple days after that. It would have probably really distasteful to have a social gathering celebrating a birthday after the former son-in-law was just murdered. So maybe Donna was like, hey, in case it does happen, we're going to cancel the birthday party. Rob also testified that Harvey didn't have any health issues or anything like that, so there shouldn't have been any reasons to cancel Harvey's birthday. And then lastly, after the first hit attempt fails, well, there's this text message between Charlie and Donna, and it looks so bad. So the hit fails, and they're still working on Dad's present, and Mom's like, oh yeah, I know you can totally do it. So again, this on its own may be a nothing burger, but because with all the other evidence put together, it starts to look really bad for Donna. Then we get into another inference with a TV appointment being AKA planning Dan Markel's murder. So Donna sets up a TV appointment. I think it was Donna and Harvey setting up a TV appointment for Wendy to have Geek Squad come in from Best Buy to repair Wendy's TV during the morning of Dan Markel's murder. Maybe that's to establish, Wendy has an alibi, because I honestly think after the first hit attempt, maybe she really freaked out and got really nervous and then was trying to not do it anymore. And the family members were like, hey, don't worry, we've got a solid alibi for you. They're not gonna, look at you. They're not gonna think that you're the one who participated. I don't know. Maybe that's what it was. And then also it was Wendy telling Jeff that, hey, Charlie tried to hire a hitman, but it was cheaper to buy a television. Not only that, I would have said, hey, maybe Jeff is lying because maybe he's a bitter ex-boyfriend. But Wendy also says it in a police interview, completely independent, completely separate, where she tells the police that, yeah, my brother Charlie said it was cheaper to buy a TV for me than hire a hitman. So one could think that TV might be code word for having Dan Markel murdered. And then lastly, what really just ties it all together, in my opinion, was the day of the bump where Donna gets that letter from the undercover agent. Donna calls Charlie and she's like, the TV is about $5. And 5 was how much money they were trying to blackmail her for. Not $5, but $5,000. So I think the jury can make a really strong inference that TV goes, Donna knowing that something is up before Dan Markel was murdered and her being part of that plan. Oh boy. And then Rob, again, also testifies that after Dan Markel was murdered, he tried to have a conversation with his mom. Mom had absolutely no curiosity whatsoever, or even the family members, about who could have murdered Dan Markel. It's as if they kept moving on with their lives and they didn't care. And then also when the hitmen were caught, I think Rob Adelson tried to bring it up again with his mom, and she just ignored it, and she eventually just hangs up the phone. So a lot of really suspicious behavior. And I think these are one of the top reasons why the jury could be like, hey, I think Donna knew about it way before September of 2014. As a matter of fact, I think she knew about it before Dan Markel was murdered. So, my argument, I think it's going to apply to the rest of the next couple pages, but we'll listen to see what else the defense says. They say, as acknowledged previously, intent is an operation of mind and may be established by circumstantial evidence. There certainly is no direct evidence Mrs. Adelson intended for Mr. Markel to be killed. However, there is also no circumstantial evidence that Mrs. Adelson wanted Mr. Markel to be killed. I disagree. Okay. Now we're jumping over to where they're talking about dropping off the money. Okay. The state's expert agreed that the state could not place Mrs. Adelson's or Dr. Harvey Adelson's handsets at Charlie Adelson's residence on July 18, 2014. So yes, they were using the cell site tower to try to figure out the locations of Donna and Harvey and then Charlie as well. They didn't have the exact GPS coordinations or anything like that. However, it seemed like she did make a drop off to Charlie because there was a whole an hour-ish plus that was unaccounted for on their trip. And then not only that, well, Donna texts to Charlie, outside your house. It's like there are certain things that just really can't be disputed, but the defense, they just go gung-ho and disputing it anyways. Well, that doesn't actually mean that we're outside the house. You know, maybe she was just texting that. And then I think they're also saying that, like, well, Donna has the codes to Charlie's garage. Why didn't Donna just go in? Well, it's because if Donna was dropping off $100,000, maybe she didn't want to drop it off unsupervised. Maybe she actually wanted to hand it off to someone who was actually there, and then someone that would be able to put it into the safe or something like that. Like, is that really that hard for the jury to come up with? Oh boy. All right, let's continue. Even if Mrs. Adelson and Dr. Harvey Adelson did stop at the residence, okay, it would have been approximately 9 hours after Mr. Markel was shot. In fact, at the state's request, the court found that Mrs. Adelson had adopted Charlie Adelson's prior testimony. This included Charlie's testimony that he paid Katie McBanwell from his own money, which he kept stable as confirmed by Katie, Ryan Fitzpatrick, the friend, by the way, and June, who was the ex-girlfriend. Charlie's testimony also included the fact that he did not tell Mrs. Adelson he paid Katie for the shooting until September 17, 2014. No evidence was presented that Mrs. Adelson was aware of anything other than Mr. Markel had been killed prior to September 17, 2014. Again, Charlie's testimony, I mean, he could have lied, right? He could have lied. The defendant in Staten drove, okay, so this is what one of the case laws that they're going to cite. The defendant in Staten drove the perpetrators to the scene of the crime, waited across the street while they were committing the crime, and then drove them in the car. In these circumstances, the jury could legitimately infer that petitioner was a participant in the crime. I mean, what I discussed earlier, I think that the jury could have also inferred that Donna Adelson wanted to have Dan Markel murdered. And then she planned it. She hired the hitman to do it, to have him killed. Not to have him scared or anything like that, because what would that do? That would do nothing, because she wanted Dan Markel to be murdered so Wendy can move to South Florida with the grandchildren. The state may argue that Mrs. Adelson's act of delivering money to her son's house sufficiently establishes what she did the day of the murder. However, nothing about delivering money after the murder could support her conviction as a principal to the murder itself. Additionally, there's no evidence of when Mrs. Adelson agreed to pay the killers prior to the murder. In fact, Katie testified during the trial that the amount of payment was never addressed prior to the murder. Listen, Katie had some testimonies that raised my eyebrows, and then also I think this was elicited in cross-examination where Jackie was like, oh, you didn't know the amount that was paid to you? Well, now they're saying, they're like, oh, look, see, Katie didn't know the amount. Well, Jackie made it seem like she didn't even believe that. I don't believe that either. There's no way maybe they're not the smartest people, I guess, right? But two people decides to kill Dan Markel, and they weren't even told how much they would get paid. What if they were going to get paid like $5,000 each, right? I just don't believe that they were not told of the amount. There had to be a discussion about the amount. There had to have been an enticing amount to get these hitmen and Katie to be involved in this, because Katie had children, okay? Well, she was going to say yes and then just not know how much she was going to throw it all away for. Don't believe that. So I think the jury can also infer that, hey, Katie could have lied in parts of her testimony. The state may also argue that Mrs. Adelson necessarily provided Mr. Markel's tag number to her son, who gave it to McBanwell, who then gave it to Garcia and Rivera, the hitman. However, there's no evidence a tag number was ever given to Charlie, let alone Katie or the hitman. Well, it's possible that she never ended up giving it to him. But the fact that she wrote it down in 2014, when it had already been a year after Wendy and Dan were separated, why would you have the tag number on there? Well, here's the thing. If Donna had testified, and then if she gave us a really good explanation for it, then I think the jury could be like, oh, okay, well, maybe, she had a reason to put the tag number in her 2014 planner. But Donna didn't testify, and she wasn't able to tell her side of the story. And lastly, for count one, at worst, even if Mrs. Adelson dropped cash off at Charlie's house after, bolded, italicized, the murder, italicized, and signed the paychecks after the murder would establish her culpability as an accessory after the fact, but are not competent evidence the principal to first-degree murder. I already discussed all the circumstantial evidence that could point to Donna knowing. Count two, conspiracy to commit first-degree murder. The state's theory on count two was that Mrs. Adelson agreed with Charlie and others to kill Mr. Markel, 37. As was clear throughout the trial, there is no direct evidence of Mrs. Adelson's involvement in the conspiracy. The state proved as to Charlie, Katie, Rivera, and Garcia. The primary evidence against Mrs. Adelson was the motive. Mrs. Adelson desired to have her daughter and grandsons move to South Florida. Although there was certainly evidence that Mrs. Adelson was not happy with the way Mr. Markel treated her daughter in the litigation process and that Donna was losing, there was no evidence Mrs. Adelson said or did anything to suggest Mr. Markel be killed. killed a year after relocation was denied and the dissolution of marriage had been settled. Well, Donna is not completely dumb, right? They made a lot of mistakes, a lot of mistakes. However, I think Donna and Charlie made damn sure that they weren't going to have, I want to have Dan murdered in writing anywhere. That's the least they can do, right? Yeah, I mean, they were smart enough to not say it explicitly, but their implicit actions and words, well, it implies otherwise. Certainly, Mrs. Adelson suggested crazy and offensive methods to her daughter to convince Mr. Markel to change his mind about relocation. Once the dissolution was final on July 31st, 2013, what evidence exists that Mrs. Adelson continued to have a motive for Mr. Markel to be out of the picture if we ignore the emails where she suggests her daughter ensure Mr. Markel be obligated to share expenses with her for their son's college education, etc., all the events which would necessarily take place after he was killed? There is none. Yes, Donna did say that, hey, make sure Dan Markel is going to pay for the son's education and all that stuff. I mean, honestly, so she wanted to take as much money as she can from Dan Markel and make sure that grandchildren were taken care of. But I mean, later on was probably when she really fleshed out, hey, let's have him murdered. Where's the evidence that Mrs. Adelson agreed, conspired, combined, or confederated with anyone else that Mr. Markel be killed? There is none. The state's entire case is premised on speculation, impermissible stacking of inferences. I think they did a really good job with this, and theory. Without the speculation theory and impermissible stacking inferences, there was no evidence that Mrs. Adelson ever agreed for Mr. Markel to be killed. I highly disagree with that. The evidence of flight was not that she was fleeing to avoid prosecution. Okay, so this is a new thing here because I think that the defense listened to Georgia Kappelman's interview post-verdict. And remember how Georgia was essentially giving shit to the defense, saying that, I can't believe that they continued the story, saying I'm avoiding... I'm not going to a non-extradition country with a one-way ticket to avoid prosecution. It's because I want to clear my mind. I want to take a vacation. And quite honestly, if you were the jury, I don't know who in the jury would ever even buy that. So here's what they wrote. The evidence of flight was not that she was fleeing to avoid prosecution, but that at the time in November 2023, she believed in her son's innocence, okay, and that if he were convicted, the state would turn their attention to her. Rather than consciousness of guilt, that is evidence of her real fear, the witch hunt would continue. But unless I'm remembering incorrectly, the defense, their story was that, remember how they had witnesses come up and testify? They had the best friend come in and testify. The other guy friend is actually saying that, Donna just wanted to clear her mind. Non-extradition country, yes. One-way ticket, yes. And then not only that, they even called Donna's former attorney to testify, saying that, Donna wanted to go to Vietnam for, just mental health purposes. But now they're saying it's because, she really believed in Charlie's innocence and she really thought the state was going to go after her next. Maybe that's the explanation that they should have used in trial instead of the other alternative, which was completely unbelievable in my opinion. Oh, and then also, wasn't it in opening and defense's closing that Donna was not fleeing? So what is it? And oh man, here they are taking a little jab at the state. The trial court exercised its discretion to determine whether a great amount of credible evidence supports one side of an issue or the other. Although the fancy presentations prepared by the state may have been persuasive to the jury, Mrs. Adelson asked the court to look objectively at the evidence, removing the improper stacking inferences on which the jury's verdict is premised. Fancy presentations in this day and age, is it really that fancy? If you're having that versus, writing it down on a poster board, I mean, sure, whatever. Take a jab if you want it. If it makes you feel better. All right, count 3, solicitation to commit first-degree murder. State's theory on count 3 was that Mrs. Adelson convinced her son Charlie to find someone to murder Markel. The evidence admitted at trial failed to establish that Mrs. Adelson asked anyone earnestly or tried to induce anyone to murder Mr. Markel. Well, I think Georgia did a really good job, and also Sarah Dugan, they did both a good job of showing the jury that Charlie was the type of person who wanted to please his mom. Donna was the matriarch, she was the domineering force, and she would direct people and tell them what to do, right? Not only were Charlie and Donna trying to tell Wendy what to do in her personal life, they would also, behind closed doors, talk about it amongst themselves. So Donna, for example, would try to convince Wendy out of something. Wendy wouldn't really listen, so Donna would get Charlie to do it because Charlie had a way of talking to Wendy. They showed this in text messages. For example, when Wendy lost relocation, she decides to buy a house in Tallahassee. Donna tells Charlie that, oh, this is a mistake that your sister is making, blah, 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 and how Donna, I guess, was unable to convince Wendy out of it. So Charlie is like, okay, mama, I got you. I'm going to go out there and I'm going to convince her otherwise. And when he did, he reported back and he's like, mama, please, let me have a pat on the back, please. Or is it pat on the head? But we saw this happening behind closed doors where these two were trying to tell Wendy what to do, even though Wendy was a grown, full adult in her like mid-30s with 2 kids. So Wendy was a people pleaser and Charlie was a mommy pleaser. Rather, the competent substantial evidence establishes that when Charlie was speaking with Miss Magbanua concerning Mr. Markel, he would at times make and receive calls from Mrs. Adelson. Katie didn't testify to any messages Charlie conveyed to her, and Charlie, although transported from prison to testify, was not called as a witness. So I think Charlie was trying to, again, insulate his mom from Katie and from the hitman. I mean, he was still the conduit, right? He's not going to just tell Katie, like, hey, my mom says kill Dan Markel. My mom says this. My mom says that. I know he complained a lot about the mom's reaction to everything that was happening, how she was having diarrhea, how she couldn't sleep, how the dad couldn't sleep, and the stresses that she was having. But he was trying to insulate his mom. He was also trying to half-ass talk in code, and then he would like decode it in the same phone. Like, it was just crazy to me. I don't think it was a big deal that Charlie wouldn't like explicitly say, oh, my mom says to do this. My mom says to do that. And then they make it seem like that he was just casually just happening to be receiving calls from Donna while he was talking with Katie in code. No, we saw the chain of the phone calls, how it was happening. You know how the state describes it as like a train where the train would only, each train cart would touch the one in front of it and behind it. It wouldn't go from like the caboose to like the front, right? So that's exactly what's happening here. It would be like Donna to Charlie, Charlie to Katie, Katie to Sigfredo, and then sometimes backwards all the way up to Donna again. And I guess this is like a little jab. It's like, oh, the state spends money to transport Charlie to testify. Well, they didn't even call him to testify as a witness. Georgia does a really good job explaining this when she was doing the interview as she was leaving the courtroom.
We didn't want to tangle with him unless we had to, and we felt like we were able to successfully get out the story that he told at his trial and marry Donna to it as much as we needed to without having to wrangle and tangle with him.
Could be a wild card. You don't know what he's going to say, right? He might still go up there and try to protect his mom. However, they were able to get essentially what Charlie was going to say about the double extortion story through Katie, through the wiretapping, through the text messages. That it was better for the state to just operate that way. Although, you know, it probably would have been more fun to have Charlie go up there again and have them cross-examine or have him go up there and direct examine him. But honestly, I agree with Georgia. I don't think they needed him at all. Maybe just have him as a backup in case they were planning. Maybe things were going to go right with Katie or something like that. So sorry, I just ate a Cheez-It, so I have some cheese like stuck in my teeth right now. But let's continue reading without the Cheez-Its. In the last portion, the defense, they're going to go after the judge. They're going to go after the courtroom. They're going to go after the judge's ruling. So starting with the ruling for the 2014-2023 planner, about like the last day of the trial, the defense wanted to include the entire portion of the planner in, and the judge was like, nope, we're only going to include what the state is going to include, which is for that month, right? So for example, in the 2014 planner, it had Dan Markel's tag number, it had his make, model of his vehicle, and this is what the defense wrote. State argued that Markel's tag number, is that another typo? In 2014 planner was evidence Mrs. Adelson provided the tag number to the shooters. Despite there being no evidence this happened. Rivera testified that there are words on the photograph given to Garcia, but no evidence was offered as to what those words were. Okay, so there were words on there. Maybe there were the tag numbers, maybe there was the make and model, or it's possible that, let's say Donna didn't even have a chance to give the plate number to Charlie, and Charlie gave it to Katie, and Katie gave it to the hitman. The fact that it's like in her planner during 2014, I think it could still be very suspicious. Very suspicious. Maybe she just didn't have a chance to give it to them. 2023 planner. I think this is actually a little more stronger in my opinion. So stronger as in I could see why the defense really wanted to have this portion in. So with the 2023 planner, remember they went to the month that I think Donna was planning on fleeing to Vietnam, and she was like selling these items. However, the defense was saying that, well, if you look through the entire portion of the planner, it goes all the way back to January, where it seems like Donna was already planning on selling these items to begin with. And my argument is that, yeah, it's possible that she'd already had, you know, a mindset to sell these items a long time ago, but maybe she was actually going to execute it before she goes to Vietnam because she knew she wasn't going to come back. So I think the argument can go either way. They argue that exclusion of the planners infringed on Mrs. Adelson's right to present a defense, and the evidence was important to defeat the argument that she was fleeing to avoid prosecution. Wait, so she was fleeing to avoid prosecution, or was she not fleeing to avoid prosecution? Next portion. When the court would rule against defendant on many occasions, the members of the gallery supporting the state would laugh out loud. Counsel for the defendant brought this to the attention of the court, and the court appropriately advised the gallery that this was not acceptable. The court did this on more than one occasion. He did. However, the conduct continued throughout the trial, and the court took no action to remove those who violated the order. Honestly, maybe the judge didn't know who was the people that were laughing. Maybe the bailiff was unable to catch who was laughing. Maybe it was like almost everyone that was laughing. I don't know. Because I think, the defense, if they wanted to, it'd probably be hard for them to figure out who was laughing as well, because it's all happening behind their backs, maybe. This undermined the credibility of the defense in the eyes of the juror. I think there were a lot of other reasons that could have undermined the credibility of the defense in the eyes of the juror or in the eyes of the gallery. The defense was just, there's just so many weird little missteps that they were taking, and people were just like, wow. It seems like they're very unprepared for today, and it was just not a good look. Not only were they laughing out loud, videos and images captured through the live video casting revealed gallery members making faces and moving about to capture the attention of the jurors while testimony was underway. I didn't see this portion. Oh, but you know what? It's because most of the time it was focused on the people that were testifying. Sometimes we would see the attorneys that were doing the cross-examining. I don't know. It just didn't really stand out to me. Maybe because I was too busy just kind of zoning on the person that it was focusing on. But maybe they could have screenshotted those and sent it to the judge, be like, hey, these are the people that are making faces. Can we make sure they don't come into the courtroom the next day or ever, right? Don't ever have them come back. This interfered with the jurors' ability to focus on the evidence and distracted them from closing arguments. I mean, that's what they think. The court admonished the defendant on numerous occasions that she was not permitted to show any emotion in the presence of the jury. Yeah.
Because of the shelf of bone that's there, it's called a glabella, so it causes a irregular entry. The first shot went through the closed car window. So the first shot would have been to the...
I do feel it is important at this point, Mrs. Adelson, when the testimony is occurring or the evidence, I know you may have a natural reaction, but as best possible...
A natural reaction?
Or the evidence, I know you may have a natural reaction, but as best possible, you need to control your reactions concerning any head movements, any expressions of disagreement, or any emotional outbursts. The jury must decide this matter on the merits, on the evidence. Do you understand this? Very well.
The law does not require the defendant to appear without any emotion. In fact, as in this case, appearing to be cold to be the seriousness and evidence in this case may cause the jury to believe the defendant had no care or concern for what the victim endured. I think there are probably other things that were actually in evidence that would probably show that Donna didn't really have a care for Dan Markel. But for example, when Donna was crying on day one, I think it's because she thought that's what the jury wanted to see. I mean, I honestly don't think Donna gives a shit about Dan Markel, okay? Either before, during, or after his death. I don't think she cared about him at all. I think that Donna wanted to try to get into the jury's sympathies by having her cry at Dan's, when they were talking about the crime scene or when they were talking about the autopsy photos, right? I think Donna just wanted to make it seem like she cared, but really she didn't, because the judge admonished her and told her to, not have any outbursts like that. And Dan Markel was brought up so many times afterwards, and not, if there were true and honest feelings that she was having and those, and true and honest emotions, then she would have probably had more outbursts throughout, right? But she didn't, because she was like, oh, the judge told me not to do it, so I'm not going to do it. That's why I just don't think I just don't think those emotions are genuine at all. During the course of the trial, prior to the reading of the verdict, the defendant did not do anything to disrupt the proceedings. Oops. She did become tearful during her first sight of the autopsy photographs and got choked up when her children appeared to testify against her. I think her getting choked up when the children were testifying, I think, that was probably some real emotions there. But the first sight of the autopsy photographs, like, you're telling me that she's never seen them before? They didn't ever go over this in evidence? Maybe she avoided it, but I don't know if I believe it. She did not speak out. She was not sobbing out loud. She was not crying out. She was, like, doing a lot with her body, though, She did need tissues to wipe away her tears, but she made no noise to distract the jury in any way. Even the victim's parents noted that she showed no remorse due to her lack of emotions during the trial. This impacted the decision of the jury, resulting in Mrs. Adelson not receiving a fair trial. Honestly, I felt like it was good for the judge to have stopped her on day one, to have her stop crying, because it just looked so fake to me, and I think maybe it helped her more in the long run, but that's just my That's just my sentiment. Again, if this was like raw emotions that she had, then it would have been hard for her to control it. And it probably would have happened many more times when they talked about Dan Markel getting murdered, getting gunned down. But yeah. The state presented evidence and testimony over 6 days. Okay. So I circled this because I was a little surprised by the judge, I guess I would say. Because I do remember how much time was allotted for each side. So for example, the state got like, I don't know, like 4 or 5 days or something. The defense says they were going to take 4 to 5 days. The defense only, the days that they were presenting their case, it was like very short. I think it was like 2 days, maybe 3. I don't know. It was when the judge was pushing Donna Adelson and her team, like, hey, she going to testify or what, right?
I don't have to choose. I was hoping I would have some time to speak to my attorney.
This has already been discussed, ma'am. What is your choice?
And so they're like, okay, well, we're going to end the day early. You talked to your client about it. They came back the next day. Is she going to testify? They weren't sure. The judge was like, okay, well, we'll have lunch to be longer. You guys decide. And then they came back and then Donna wasn't sure. And the judge was like, okay, well, we're going to have more people testify. And then you think about it. So the judge wanted to know, Donna Adelson, are you going to testify or what? And up until the very end, she still was very unsure of whether or not she was going to testify. The judge was not happy. And the judge was like, okay, well, you had pre-trial to think about it. You've had, during the trial, you had the lunches, the breaks and all that stuff. And it's not like you weren't present for your trial at all. It's not like you weren't present during the pre-trial stuff. Why am I so nervous?
I am not talking for the sake of talking. Before we have to move into any contempt, we do need to move on. Mrs. Adelson, the question remains. As it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
But because, the defense said they were going to take 4 to 5 days and it took way less than that, I guess they had way less witnesses that were going to testify. I just feel like, I don't know. I thought that maybe the judge would give her like another day to think about it. But he was like, no, I'm not playing games. We ain't doing this. The state presented evidence and testimony over a period of 6 days. The defense had requested 4 to 5 days for its case. On the second day of the defense's case, the court demanded that Mrs. Adelson decide whether she would testify. Both counsel for Mrs. Adelson as well as Mrs. Adelson herself repeatedly advised the court that more time was needed to discuss the evidence admitted and the pros and cons of testifying based on the volume and the substance of evidence admitted during trial in order to make a knowing and intelligent decision in what was probably the most important decision in her life. This was especially significant in what the state made numerous changes to evidence during the trial. 6-9. When the court recessed early on September 2nd, 2025, to allow counsel to meet with Mrs. Adelson, we spent a great deal of time reviewing the exhibits actually admitted so that we would discuss them with Mrs. Adelson. Counsel then drove to the detention center to meet with Mrs. Adelson for 2 hours authorized, arriving approximately 5 p.m. Counsel did not have enough time to go over every exhibit with Mrs. Adelson during this meeting. Counsel advised the court of this fact the following day when the court inquired about Mrs. Adelson's decision. Not only did the court force the defendant to make an uninformed decision, he threatened to hold counsel for the defendant in contempt of the court because they were continuing to speak to their client about this important decision she had to make. Yeah, there was a part where I think Mr. Zalman was like, hey, Jackie's been talking to Donna. Let me give it a shot. And the judge was like, well, what are you going to do that's different? He's like, well, let me just talk to, to Donna. He's like, okay, I'll give you 5 minutes. So 5 minutes goes by and the judge comes back on the screen and he was like, he starts talking and he's like, hey, I'm not talking just for the sake of talking. You guys, come back right now, give me your decision, or I'm going to hold you guys in contempt of the court. I was like, oof. Which again brought an audible derogatory response from the gallery. Oddly enough, when the state needed additional time to set up electronics for opening statement, for witness testimony, for closing arguments, and even additional time to make their closing argument, the court not only gave them additional time, he joked with the prosecutors about it. I think that's different though. It's like they're setting up for their presentation. It's not like they were ill-prepared or it's not like they were slacking or anything like that. Thus leaving the clear impression that he favored the state in this case. Surely the decision of a defendant facing life in prison is more important than the extra time the state requested to conclude its closing argument. The defendant's request was not granted and made a huge impact on the outcome of the case. I don't know. I thought the defense there were certain times where the defense requested more time from the judge and he gave it to them. But maybe that didn't happen. But I feel like there was something though. I can't think of it on top of my head. I could be wrong. The court showed favoritism to the state at almost every juncture of the trial. While the trial had delayed certain times to accommodate the state's needs, the defense was required to meet its task over the lunch break, thus not allowing counsel time to adequately meet the obligations of the counsel for the trial, resulting in the inability to consume lunch over the break. Yeah, that really sucks. When you're working during your lunch break and you don't have time to actually take a break, to eat properly, to drink and all that stuff. But, you know, I don't know what's going on behind, closed doors, but the impression that I got was just that, there's just... It seemed like the defense was just not very prepared, in my opinion, but it could just be that they had way less time to be on this case. But I don't know. I just didn't really get the best vibes from them. The court sustained the objections of the state without giving the defense an opportunity to respond. Under some situations, sidebar arguments were made, but on more than one occasion, the court denied the defense's request to approach. Yeah, I remember that. I think Zelman was like, "May we approach, Your Honor?" He's like, "Nope," and then people left.
Judge, may we approach?
No.
Additionally, when the court sustained a defense objection at sidebar, when the sidebar was concluded, the court announced to the jury that objection was overruled. I mean, I wouldn't imagine the judge doing this on purpose to make the defense look bad. It could just be an honest mistake that the court made, right? Let's say that it was sustained, and then when he announced it to the jury out loud, he accidentally said overruled, but he said the wrong thing. So I don't know. Did Mr. Zelman, did Jackie, did they try to correct it for the record, maybe? I don't know if they did. During one sidebar discussion, the court asked counsel a question. As counsel attempts to answer the question, counsel was met with a scolding to not talk over the court. Counsel thereafter was prevented from answering the court's questions. If I remember correctly, I think Georgia may have gotten a little bit of some scolding as well when she was trying to steamroll over and talk, and the court cut her off a few times. 75. The temperament of the court towards the defense counsel was regarded as negative and gave the appearance of partiality for the state on the part of the court. And I could see that, to not only the defense, but spectators in the gallery, the media, those viewing the trial through the media. Fellow defense attorneys commented that they had appeared before the court in trial on similar charges, and they were shocked to see the obvious disdain the court showed towards Mrs. Adelson and her counsel in this case. I think maybe more people were probably shocked that maybe Donna didn't get more time to think about whether or not she was going to testify. Although there is a standard jury instruction to the jury that they are to disregard anything the court may have done that led them to believe he favored one outcome over another, and that was read in this case, it is not realistic that a jury can set those feelings aside. The jury clearly disregarded the instructions of the court on the other issues and did so on this instruction as well. I don't agree with that portion. The totality of circumstances present during Mrs. Adelson's trial established inherent prejudice, to wit, there was an unacceptable risk of impermissible factors coming into play. So they want to have this motion to be granted. They want Donna to have a new trial. They want the jurors to be investigated and questioned. And then they want to potentially just, have the jury's verdict be thrown out and have a new trial in place. So we'll see what Georgia says. I can't wait to hear from Georgia's response. I'm assuming, Georgia's probably cracking her knuckles right now. She's like, I'm ready to reply to this. Oh, Cheryl says hi, by the way. So we'll wait for Georgia's reply and her response. But yeah, that's it for now for the defense's team. I mean, we already knew that they were going to file a motion for a new trial. So it's not anything crazy or anything like that. But it is interesting to see what their arguments are. And I think one of their strongest arguments, or the one that I was really, generally a little confused about, was the judge not letting Donna think about it overnight for her to testify. But again, maybe the judge just generally believe that Donna had enough time to think about it and that maybe she was just trying to stall, I guess. So, all right, guys, thank you so much for watching. If you guys did not watch the trial, or if you're like, hey, I want to know what happened on a certain day, we did recaps of the trial. Feel free to go check it out. Also, news about Alexi Treviso. The Supreme Court had their hearing recently. I did a recap of that. Feel free to check it out. And I'm going to go back and work with the Koberger stuff. All right, y'all? I was working on Koberger and then this popped up. So I just set the Koberger side. So we'll go back to Koberger stuff. And other than that, y'all, I hope you guys have a good one. Take care. I still have cheese in my mouth. And I'll see you guys next time. Maybe on the live stream or something like that. I'm not going to stream this week, though. I don't think so. So maybe next week. Bye.